Okay, now that we have everybody, this is Orr versus Legacy Physician Group, PC et al., docket number 19-387CB. This was the defendant's motion for summary disposition. We've already had a briefing, obviously, and oral argument that went quite long on the day that it was held. And so I deferred making a ruling to a later date, and that date is today. So I'll get right to it since we got a late start. This was the defendant's motion for summary disposition. It was brought under C8 and C10. And the plaintiff has replied saying that the motion's premature because discovery is not complete. Rather than address that at the outset, I'm going to leave it for now because the first issue I'm going to address is count 3, breach of contract. And I believe that can be decided under C8, looking at the contract itself only. So the discovery issue really isn't relevant. So count 3 requests declaratory judgment regarding a breach of contract. The count is limited in its allegations, but it appears to be alleging that the plaintiff was wrongfully terminated and wrongfully kept from benefits under the contract. And again, I think this is a count that can be decided without regard to the state of discovery, which I will address later. First, there are no allegations in the first amended complaint, and nothing has been asserted in response to this motion to support how the plaintiff was wrongfully terminated. There's no provision in any contract that the plaintiff has pointed to. There's no standard asserted for termination that comes from either a contract or by law. There simply is no basis, no allegations, and no basis for any wrongful termination claim. But really the focus of the breach of contract claim and the first amended complaint as a whole seems to be more on the issue of valuation of shares, and I assume that's what's meant by the plaintiff being wrongfully kept from benefits under the contract. So I'll address that. The contract is the buy-sell agreement. The defendants say that it's unambiguous and that paragraph 6 requires that upon termination of employment, the corporation purchases the shareholders' shares at a purchase price that's set forth on Schedule A. Plaintiff says there's a conflicting language in the buy-sell agreement that specifies that the remaining shareholders have the exclusive right to the stock repurchase in the event of shareholder termination. And although the plaintiff fails to expressly state this, the implication is, at least to me, is that the shareholders would negotiate a sale price with the departing shareholder and the price schedule on Schedule A would not apply. While that argument isn't expressly made in the plaintiff's response to this motion, the first amended complaint is based on an allegation that there's been no good faith negotiation of a price for the shares. So back to the buy-sell agreement and the issue of whether it is ambiguous or not. The language that the plaintiff points to is contained in the whereas clauses, which states, whereas, therefore, it is their mutual purpose to provide for the purchase by the shareholder of a shareholder's shares should the shareholder become disabled for more than 1 year, or should his or her employment with the corporation terminate. And that is in contrast to the paragraph 6, of course, that the defendants are relying on, that, as I've mentioned, provides for the corporation to purchase the shareholder's shares at a price set forth on Schedule A. I cannot agree with the plaintiff's claim that this whereas clause creates an ambiguity. This is a whereas clause that merely states the general purpose behind the contract. It's not the substantive agreement of the parties. The substantive agreement of the parties starts following the whereas clause, where it says, quote, the parties hereto agree as follows. The other reason that I can't agree with the plaintiff's claim that this creates an ambiguity is that a contract is ambiguous when it's subject to two conflicting reasonable interpretations, or it has irreconcilably conflicting provisions. I just can't conclude that a whereas clause that only states the parties' general purposes to entering into a contract is a conflicting provision with a substantive paragraph that actually forms part of the parties' agreement. And finally, even if I were to give the whereas clause the same effect as the substantive provisions of paragraph 6, it simply does not get me to where the plaintiff wants to go. And that appears to be not so much who purchases the shares, but that the price for the shares on Schedule A does not apply. However, all the provisions in a contract have to be considered and given effect. And whether it's a shareholder as stated in the whereas clause or the corporation as stated in paragraph 6 that purchases the shares, the purchase price as set forth in paragraph 6 would have to be applied in cases of termination. And that is the purchase price expressly stated in paragraph 6 to be the price on Schedule A. Paragraph 6 is simply unambiguous, and the buy-sell agreement as a whole is unambiguous. Upon termination of employment, the substantive provisions of the contract provide that a shareholder's shares are purchased by the corporation for the price shown on Schedule A. Defendants are entitled to summary disposition under C8 on count 3, breach of contract. I would apply the same analysis to well, no, it's a different analysis, pardon me. I will now address count 2, minority shareholder oppression. And the dispositive portion of this part of the motion is that the plaintiff was not a minority shareholder and doesn't even attempt to show how he could have a minority shareholder oppression claim. The argument that he is a minority shareholder when the other shareholders together act against him is just completely untenable. It actually would turn every shareholder, no matter how many shares they had, into a minority shareholder. But he's not. He's not a minority shareholder because he has equal shares with everybody else. And that is the test for, and it's quite simple and straightforward, for whether someone is a minority shareholder. It's whether they hold a minority of shares. That issue alone disposes of the minority shareholder oppression claim, but I'll also address 2 other issues. The first is that a majority of the shareholder oppression claim, and even a majority of the First Amendment complaint, again, appears to be based on the plaintiff's complaint that he's not been given the opportunity to negotiate a price for his shares. That entire claim, in any form that it's in, fails because as I've already found, the buy-sell agreement unambiguously provides that when a shareholder's employment is terminated, the corporation purchases his shares at the price set forth in Schedule A. The second issue I'll also address is the argument about the amendment of the minority shareholder oppression statute. The 2006 amendment added that, quote, willfully unfair and oppressive conduct may include the termination of employment or limitations on employment benefits to the extent that the actions interfere with distributions or other shareholder interests disproportionately as to the affected shareholder, end quote. Plaintiff seems to argue that merely terminating his employment constitutes shareholder oppression. That is not the case. Termination of employment alone is not enough. It has to be unfair and oppressive conduct. And again, the plaintiff is not a minority shareholder. So the defendants are entitled to summary disposition on count 2 as well. So just to summarize how I've ruled so far, I'm granting summary disposition to the defendants as to count 3, breach of contract, and count 2, minority shareholder oppression. And this is only under C8 because the contract is unambiguous and because plaintiff, undisputed, is not a minority shareholder. That's an undisputed fact, and there's no factual development that can change that. Turning now to count 1, breach of fiduciary duty. Another shareholder owes a fiduciary duty to the plaintiff only if the other shareholder owns a majority of shares or exercises actual control and direction over corporate management. In this case, it's undisputed again that all the shareholders held an equal number of shares. Therefore, whether there's a fiduciary duty or not depends on whether Dr. Fedowa or Dr. Joseph actually controlled and had direction over the management of the corporation. I assume that is the theory that the plaintiff was going on because the First Amendment complaint does briefly allege control and management in paragraph 35. But whether that can be shown would be fact dependent, and the plaintiff says that discovery is incomplete. So here I have to address the discovery issue. Per the parties' stipulated order, discovery ended on November 1st. The plaintiff has filed no motion to extend discovery for good cause. The plaintiff says the defendants have not complied with discovery, but it doesn't appear that way from the emails that I reviewed that were submitted by both sides between counsel. Admittedly, it appears, especially from argument that was made last time, that there was some confusion about the defendant's documents submission, but it is also clear that all documents have been submitted as of about 3 months ago. I've not had any motion by the plaintiff to compel discovery. The defendants, as far as every bit of information that I've been given, have complied with all written discovery requests. The plaintiff was the one who was compelled to comply with discovery, but the plaintiff now says that there are no documents to produce on behalf of the plaintiff. Turning to depositions, the deposition of Dr. Joseph was scheduled and she appeared apparently, but it was counsel for plaintiff that terminated it. Dr. Fedowa has not been deposed, but I saw nothing in what was submitted to the court to indicate that the plaintiff ever even tried to depose Dr. Fedowa. She's a named defendant in this lawsuit, and if the plaintiff believed that her deposition was essential, then the plaintiff should have scheduled it. I just see no justifiable reason for depositions not to be completed other than the plaintiff just hasn't done it. The plaintiff also just makes general assertions that discovery is incomplete. I think at this stage there has to be more than that. There has to be some specific statement about a specific witness and specific information that the witness would be expected to testify about. And there is some of that, I admit, in the plaintiff's response, but here's where it really boils down to, in my opinion. The plaintiff was an equal shareholder in this company. And if there are facts to support that Dr. Fedowa or Dr. Joseph exercised actual control and direction over the management of the corporation, then those facts would be known to the plaintiff. So even if we put aside the depositions of Dr. Fedowa and Dr. Joseph, the question has to be asked, why, if those facts could have been known to plaintiff, is there no affidavit from even the plaintiff saying that these are the things that would indicate control and management of the corporation? The plaintiff hasn't even submitted his own affidavit, let alone anyone else's, to avoid summary disposition under C10. So at this stage, we're left with nothing to show that there's any factual support for the requirement of count one with breach of fiduciary duty, which would be that Dr. Fedowa or Dr. Joseph actually controlled and had direction over the management of the corporation. So for that reasons, the defendants are entitled to summary disposition under C10 as to count one. Again, because the plaintiff's unable to support the claim that any other shareholder owed him a fiduciary duty by virtue of either owning a majority share of stock, which everyone admits they did not, or exercising actual control and direction over management of the corporation. And that takes me to count four, which is the count entitled defamation per se. The first amended complaint alleges that defendant Fedowa made multiple false statements to multiple different people about plaintiff diverting drugs. And although the complaint calls this defamation per se, I can't necessarily make that conclusion. Defamation per se applies when a statement is made about someone having committed a crime. It doesn't excuse any of the legal requirements of a defamation claim, except with respect to damages. Defamation per se does not require proof of damage to reputation. But again, all of the statements alleged here are that plaintiff was diverting drugs. I can't conclude that that's a statement about commission of a crime, but I only say that because the plaintiff in briefing repeatedly characterizes it as a heinous crime. And I don't necessarily think that that is true. But the real issue here, turning back to the defamation claim, is whether Dr. Fedewa has qualified immunity. The plaintiff's argument in response to this motion is that Dr. Fedewa cannot have qualified immunity because Dr. Fedewa never supervised the plaintiff. But qualified immunity does not require supervision. Qualified immunity can apply in a variety of different situations. It's not limited to just employment or supervisory relationships. It applies to all communications where a party with an interest or duty with respect to the subject matter communicates with another party having a corresponding interest or duty. So qualified immunity would absolutely apply to statements Dr. Fedewa made to the Michigan Board of Medicine. And plaintiff fails to address why Dr. Fedewa, as an equal shareholder in the corporation and as a medically licensed doctor with prescribing authority, would not have an interest and even an obligation to report any mishandling of medications. And in fact, it's the first amended complaint that says exactly that in paragraph 28. Quote, all officers and shareholders of Legacy Physician Group are required by law to report any unlawful removal of controlled substances, end quote. That said, the complaint is required to allege specific statements to specific persons, and I can't even conclude that the Michigan Board of Medicine is even alleged because it's not one of the allegations in the complaint. So to me, this entire argument about the Michigan Board of Medicine is a red herring. The first amended complaint actually alleges 9 people to whom statements were made. Plaintiff's response to this motion makes only the briefest of references to remarks Dr. Fedewa, quote, had repeated dozens of times, end quote. Again, Dr. Fedewa may indeed have qualified immunity with regard to these people, depending on who they are and whether they share an interest in the subject matter with Dr. Fedewa, but it's impossible to assess that when the plaintiff doesn't provide an adequate response. The plaintiff does say that Dr. Fedewa, and this is where the plaintiff points to some specific statements about depositions and testimony. The plaintiff says that Dr. Fedewa will be forced to admit that there is no evidence for diversion of drugs once she is deposed. To which I say that I still don't have any valid reason why the plaintiff hasn't deposed her. And if the plaintiff wanted to survive summary disposition on a defamation claim, the solution is simple. Obtain an affidavit from even just one of the 9 people that are alleged in the first amended complaint. But the plaintiff hasn't done that. I'm granting summary disposition to the defendants, defendant, this is only against Dr. Fedewa, to the defendant under C8 as to qualified immunity and under C10 for failure to demonstrate a genuine issue of material fact on the defamation claim. And that takes us to count 5, intentional infliction of emotional distress. This count is not very detailed. It does incorporate all the preceding allegations in the first amended complaint. So I presume it is based on terminating the plaintiff's employment, refusing to negotiate the price for his shares, and making false and defamatory statements about diverting drugs. I've already addressed the termination and the price for the shares. There's no basis for either of those allegations, so they likewise cannot support an intentional infliction of emotional distress claim. As to the alleged defamation, I cannot conclude, as plaintiff suggests, that Dr. Fedewa said that plaintiff committed a heinous crime. Diversion of drugs could mean that plaintiff charged prescription drugs to the corporate account that presumably were not for use in connection with Legacy Physician Group. The problem is, one, that doesn't tell me that's a crime, but two, the plaintiff admits this in his response brief. And it is initially for the trial judge to decide whether the defendant's conduct might reasonably be regarded as so extreme and outrageous as to allow recovery for intentional infliction of emotional distress. So that is supported by the case that the defendant cited, Roberts versus Auto Owners Insurance Company, 135 Mich. App 595, that the court acts as an initial, I don't know if you want to use the word gatekeeper, but in any event, the allegations have to rise to a certain level, even for a motion for summary disposition in order to go forward. I cannot conclude that saying that the plaintiff diverted drugs is so extreme and outrageous that it supports an intentional infliction of emotional distress claim. Although it's not entirely clear, the intentional infliction of emotional distress claim appears to be against all defendants, but again, that count is very sketchy and vague. But I am granting summary disposition for the defendants on the intentional infliction of emotional distress claim under C8, because as a matter of law, and under that Roberts versus Auto Owners Insurance Company case, as a matter of law, the allegations cannot support extreme and outrageous conduct. So I think I've covered all the counts. I've covered the motion for summary disposition in its entirety, and I am granting the defendant's motion for summary disposition for the reasons stated and under the sections of the court rule for the particular counts as I've indicated. So if you want to do an order, Mr. Davis, I'll sign it.
Okay, Judge. Thank you very much. I will do so.
Thank you.
Have a good day.
Thank you.
Thank you, Your Honor.